Hello everyone, my name is Bert Paulson and my Pecha Kucha presentation will be discussing the case between Fredericks versus the California Teachers Association. This case took place between 2015 and 2016 and it challenged the constitutionality of public sector forced unionism. This took place in Buena Park, California during the 2015-2016 school year. It was first brought in the Supreme Court June 30th, 2015. Rebecca Fredericks was in her 28th year teaching in the California public schools, and she was not a part of her school's union, so she was known as the agency fee payer, who had to pay 100% of the bargaining fees for the union. A little background on this. The first case for unionism took place in 1977, where the case between Abood versus the Detroit Board of Education. Supreme Court upheld the maintenance of a union shop in a public workplace. This case was supposed to be overruled with public sector agency shop arrangements invalidated under the First Amendment. The 77 case said it violated the First Amendment to require that public employees affirmatively object to subsidizing non-chargeable speech by public sector unions. Rebecca Fredericks was the lead plaintiff for this case along with Terry Pell, who was the president of the CIR, or the Center for Individual Rights. Alongside those two were teachers Josie Manso, Peggy Searcy, and as well as 8 other California teachers, and even the Christian Educators Association International jumped in for the fight. Rebecca Fredericks and the other teacher plaintiffs are asking the Supreme Court to overturn the 77 Abood case decision. They argue collective bargaining in the public sector is inherently political, and the government and unions devote more resources to their political agenda than just small portions of dues, which goes directly to support political candidates or causes. The Center for Individual Rights filed suit in the United States District Court for the Central District of California on behalf of Fredericks and 9 other California teachers and the Christian Educators Association International, challenging the constitutionality of California's agency shop law that violates the First Amendment by forcing public school teachers who are not members of the union to nonetheless pay the annual fees. The district court granted the request to enter judgment on behalf of the defendant unions of Fredericks versus the California Teachers Association and the challenges to compulsory union dues. The decision means the case can proceed to the Court of Appeals of the Ninth Circuit without discovery or trial. The decision means the case can proceed in the Court of Appeals for the Ninth Circuit without discovery or trial, both of which have delayed the case significantly. All these parties agree that the case raises a pure issue of law that can only be decided by the Supreme Court. In September of 2014, all parties have now submitted the briefs on the merits to the 3-judge panel that will hear the case for the Ninth Circuit. California law allows unions to become the exclusive bargaining representative for the public school employees of that district and therefore have a great deal of influence over a wide range of conditions of employment. Once a union is the exclusive bargaining representative for the school district, it may establish an agency shop arrangement. Because the First Amendment prohibits unions from compelling non-members to support activities that are not exclusively devoted to negotiations, contract administration, and other duties as an exclusive bargaining representative, unions must send notices to all non-members laying out the breakdown of the chargeable and non-chargeable portions of the fee. To avoid paying the non-chargeable portion of the fee, a non-member must affirmatively opt out each year. April 14th, 2015. Fredericks and 9 other California school teachers of the Christian Educators Association International filed their final brief urging the Supreme Court to take Fredericks versus the California Teachers Association in order to overturn the court's 77 decision of Abood versus the Detroit Board of Education. September 23rd, 2015. 25 parties have filed amicus briefs at the Supreme Court in support of the Center for Individual Rights case. The amicus briefs represent the board, or the broad and bipartisan coalition of individuals and organizations who agree that compulsory union dues are harmful to teachers, parents, and children. A host of public interest law firms filed briefs, including the Pacific Legal Foundation and the Beckett Fund for Religious Liberty. The union, the state of California, and the Obama administration filed briefs in an attempt to justify their position that the First Amendment does not protect public school teachers. The Center for Individual Rights filed reply briefs that forcefully argue in defense of the First Amendment. January 11th, 2016, the Supreme Court will hear oral arguments in Frederick versus the California Teachers Association. This case will decide whether California and 22 other states can compel public employees, like public school teacher Rebecca Fredericks, to pay union or agency fees, and the arguments would last only 48 minutes. February 13th, 2016, Justice Antonin Gregory Scalia, who was on the Supreme Court, dies unexpectedly of natural causes, leading to an even number of judges and pushing the date back for the voting. Although unexpected, this was a problem for the potential outcome of Fredericks, and the death was caused by natural causes. March 29th, 2016, the Supreme Court issued a 4-4 split ruling in the Fredericks versus the California Teachers Association. The split decision allows the Ninth Circuit ruling to stand, but does not establish a precedent for anywhere else in the country. A full court with a new justice may rule in favor of the First Amendment rights of public employees. The Fredericks attorneys are petitioning for the case to be reheard when there are 9 justices instead of 8. Another case could also be brought before a new court defending the public employees' freedom of speech of association. And on April 8th, the petition was denied. If Fredericks would have won, it could have inflicted a potentially devastating financial blow against the California Teachers Association, and by extension of all public employee unions. Terry Pell, who was the president for the CIR, the nonprofit public interest law firm representing the plaintiffs in the case, said he was greatly disappointed in the court's decision to not rehear the case. Frederick's comments were, "My heart is broken for America's children and families, as their teachers will continue to be forced to fund policies and highly political collective bargaining processes which place the desires of adults above the rights and needs of children. I'm grateful to the thousands of teachers and parents who have stood beside my fellow plaintiffs and me. Our kids are worth the fight." Effectively, such a decision would convert the 26 states that now require union membership into open shop states. If the justices rule in favor of Rebecca, the government workers across the country would not need to pay unions as a condition of employment. Workers in the 25 right-to-work states already have the right, and some government workers in a few non-right-to-work states have similar rights. This means that such a decision would only affect workers in roughly half the states in the country. Thank you so much for watching and listening to my Pecha Kucha about the case between Fredericks versus the California Teachers Association. I hope you got just as much out of this as I did.